Hello friends, welcome to my channel. Today we are discussing the two basic concepts of constitutional law, that is constitution and constitutionalism. Let's begin with the concept of constitution. What is constitution? Now, according to Kelson, as he given the very Grund norm theory, and in his Grund norm theory he said that in every legal system there is a basic law which is known as a Grund norm, and for the legality and validity of all other norms in the legal system there must be the confirmation from the Grund norm. If we equate this theory with the constitution, we understood that constitution is also the fundamental law which gives the principles of the government, and in this various rules, regulation, laws whatever made in the system, they derived their legality and validity from the constitution. Constitution further provides organization, structure, functions, composition of various organs of the government. For example, in our system, as we understood that there is a legislature, executive and judiciary. In the constitution, we understood that the powers, functions, composition, organization of legislature, executive, judiciary rightly laid down. Further, constitution demarcate the powers of government and it seeks to limit those powers. So it is expected by the constitution that whatever the organs are there in the government, they should not act in a arbitrary manner. Rather, they should act in a particular frame whatever provided in the constitution. And there the concept of constitutionalism came to understood or arose, you can say. Now in the constitutionalism we are understanding that not only government but emphasis is always on the limitation on the part of that government. So in the constitutionalism we are not only understanding what are the functions, what are the organization, what are the composition of government, but the real emphasis is always there on the concept of limitations, checks and balances, control mechanism on the various organs of the government. And so constitutionalism provides that the organs of government with power and checks and balances on the exercise of power should be maintained in the legal system. Say for example, organs of a government like a legislature equipped with the basic function of lawmaking. It doesn't mean that the legislature should blanketly use that power. If legislature in an arbitrary manner, unreasonable manner, they are making that particular laws, then the constitutionalism can limit that particular arbitrary exercise of power by the legislature or by the parliament. So we could understood that constitutionalism is an antithesis of arbitrary or unreasonable use of power or exercise of power by the organs of the government. Now constitution expected that it should operate with the constitutionalism. Rather, without constitutionalism, the constitution is a mere document. The constitution confers power on government, but constitutionalism restrains it from becoming absolute and arbitrary. So it is a necessary that the constitution should operate with the constitutionalism. Constitutionalism, in a very brief, protects the liberty, freedom and fundamental rights of the individual. And so it is not only sufficient to have a constitution, but along with that constitution there is a need to maintain the constitutionalism in the system itself. And so when we are talking about the concept of constitutionalism, now in this concept of constitutionalism we have to understand what society expects, whether society need a constitution without constitutionalism or whether society needs constitution with constitutionalism. So but naturally society always needs constitution with constitutionalism. Constitutionalism makes constitution a living organ, because when we are saying that there is a need to protect the fundamental rights, liberties of the people, social justice, collective interests of the society, then at that time there should be some test to verify the very operation of government or the policies of the government, and that test can rightly be adapted with the help of concept of constitutionalism. And so whenever any policy of the government, any law which is made by the parliament, or any executive action which is implemented or executed by the very administrative organs of the government, there plays a constitutionalism important role to control that particular actions of the government. And so fundamental rights, basic structure of the constitution, independence of judiciary, right to equality, protection of minorities' rights, process of elections, these are the very examples which enhance the constitutionalism. And so in our constitutional philosophy we understood that constitution should be operate along with the constitutionalism. It is nothing but the government, that is a limited government, and limitation on the part of government. And so in this particular scenario we have to understand that without constitutionalism, constitution cannot operate in a fair manner. Now the concept of constitutionalism is not a new one. From the ancient philosophy, or from the beginning of concept of very natural rights and natural law, again and again we are emphasizing on the basic rights of the individual, inalienable rights of the individual, or the equality as a natural right of a person. These are nothing but the very elements what we understood as a very elements of the constitutionalism. Rather, with these elements constitutionalism got strengthened in the legal system. So in the country where the dictatorship is there might be a constitution, but you cannot guarantee that there is a constitutionalism. Constitutionalism operates with the very philosophy of limitation on the part of government. So government should not be like a blanket license government to do whatever they can. Rather, government should be with somewhat restraint, with somewhat limitation, so that the rights of the citizen can be effectively protected in that legal system. So with this particular note, I am stopping here with this video. Thank you for watching this video.